Moving on, we're now on item number 4, which is 2020-4285, access self-storage. We've got Councillor Morgan here. He's going to speak on behalf of his residents. Councillor Morgan, have you got a mic? Are you going to come down and do you want to come and sit over here? And then you can do your bit.
Okay.
So yes, Councillor Morgan, would you like to introduce yourself? You've got 5 minutes to talk to the committee and tell us whatever you think you'd like to on behalf of your residents. Thank you.
Brilliant, thank you very much. My name is Roger Morgan. I'm one of the Conservative councillors in St Mary's Park. Residents have asked me to raise a number of issues on their behalf about this application, which can be grouped into 3 main themes, with these being the size and massing of the proposed building, the use of space and the type of housing the building offers, the impact the development would have in exacerbating ASB and crime-related issues in the area. Turning first of all to the size and massing of the proposed building, the new development ranges from 8 to 13 stories, while my colleague Councillor Melanie Hampton and I have strongly advocated on behalf of residents in order to bring the proposed height down to this level from the original proposed height. The building is still too high for many residents who live in the area. This is demonstrated by the fact that over 520 objections have been received from local residents about the proposals. The sheer number of objections shows the real strength of feeling from residents against these proposals. The proposals also plan for 193 shared living rooms and 131 build-to-rent residential units. In terms of impact on amenity, the sheer scale and massing of this building will lead to a number of issues, including, but not limited to, a loss of light to Riverside Plaza, Battersea Reach and Chalmers House, loss of privacy from windows and communal terraces for a number of residents. Turning next to the use of space and the type of housing this building offers, firstly, the plans outlined in this application would lead to a net loss of employment space. While some is being re-provided, it is not to the level that was offered before, and this is contrary to Part 5 of Policy E13 in Wandsworth's Employment and Industry document. Secondly, this offer will not solve the housing issues which we're experiencing in London and the wider UK. It merely kicks the can down the road. Rather than having such a large focus on co-living, this land could instead be used to create more permanent homes for families. A number of different companies are also planning or proposing to build large-scale co-living developments in this one ward, St Mary's Park. This creates a number of significant challenges for people who already live here. The co-living model is not a proven one in the UK. As I've already said, there are at least 3 companies who would like to build these kind of developments in this ward. One of these businesses, The Collective, which was also planning to launch a very similar offer to this one, very close to the proposed access storage development, went into administration last year. An article written about this case said, the nascent co-living market and its small units and focus on shared amenities has been hit hard by the pandemic. Having lived through 2 years of pandemic, it seems very likely that many people will now be sceptical about living in this kind of development. As another article about The Collective said, demand for rooms at its properties fell during the pandemic as people left city centres and prioritised larger private living areas as they spent more time at home. This presents a risk that the units would not be occupied, detracting from an inclusive and high-quality urban neighbourhood. When there is a need for more family-focused accommodation in London, these proposals look like a very poor use of land. Also, looking at the proposals, 46% of the buy-to-rent homes are one-bedroom properties. According to DMH3, the percentage of one-bedroom properties should be no more than 20%, so at 46%, it is more than double what is deemed acceptable. Also, the Local Housing Needs Assessment, published in 2020, said it expected that the focus of new market housing provision will be on 2- and 3-bedroom properties. It also concludes by saying that conventional forms of housing should be considered before shared living. It is not fair to residents of St Mary's Park that our ward should be used as a testbed for an experimental and unproven concept, especially when there does not seem to be a demonstrable need for this housing tenure type. Instead, this land could be used to provide longer-term homes for residents, including affordable homes. Turning finally to the impact the development would have in exacerbating ASB and crime-related issues in the area. Importantly, the proposal seeks to remove the northern boundary wall between the application site and Battersea Reach. This is a huge concern for a significant number of residents who live at Battersea Reach. Any plans relating to the use of green space and the pathways for this development should be, at the very least, be a reserved matter to be decided at a future meeting of the Planning Applications Committee. And for very good reason. As already mentioned, there are already issues of ASB and crime in Battersea Reach, which have only got worse in recent years. The Battersea Reach Residents Association believes that these plans have been reviewed, when these plans have been reviewed and considered, not enough weight has been given to residents' concerns about crime and antisocial behaviour. Serious issues and crimes that already relate to this area include, but are not limited to, attempted housebreaking, bicycle theft, theft from cars, drug dealing, and mail theft. Owing to many of these issues, my colleague Councillor Melanie Hampton and I arranged for a meeting between local police officers and some residents from Battersea Reach, which took place last year. Residents worry that if this northern boundary wall is removed, then it will make Battersea Reach even more permeable and will lead to even more issues here. A number of residents have raised concerns with us. If this wall was removed, it would lead to a number of security and privacy concerns, especially in relation to the nursery that is located nearby. There are already a number of other points in this area where people can access the river path, so another access point is not needed here. Based on all of these issues with the proposals, I'm asking that this application be rejected tonight. Thank you.
Thank you, Councillor Morgan, for packing a lot in there into what is a very complicated application. So yes, colleagues, yes, quite a complicated, multi-faceted application, this one. So questions or comments, anybody? Oh yes, I beg your pardon. Yes, sorry, Mr. Wilson's going to give us a presentation just on the overview first, because it is quite complicated. So Mr. Wilson, would you like to say hello to everybody and do your presentation, then we'll go on to questions.
Thank you, Chair. I'm Thomas Wilson, Senior Planner.
This is somewhat of a first, isn't it? Having the person in the room and presenting at the same time, so there might be some teething issues.
Got it up now. Right, the application site lies between the River Thames and York Road. It comprises of buildings up to 4 stories high that are operated by Access Self-Storage. To the east of the site is Mendip Road and a presently under construction 8-storey shared living development. To the north is Riverside Plaza, the nearest building of which is presently being extended to 8 stories high. To the west, the site is flanked by the Battersea Reach estate, and specifically Jenner House, Flotilla House and Ensign House, with the tallest of those being 16 stories high. A petrol garage is also located to the west of the site. To the north of the site is a pocket park and a footpath leading from the northern boundary of the site to the Thames Path. These form part of the Battersea Reach estate. The first photo is looking down along Mendip Road. It shows the Access Storage building set back from the street. The first photo on this slide is of the existing buildings fronting onto York Road. The Shell petrol garage lies just to the west of the building. The second photo shows the existing aforementioned footpath running from the Thames Path down to the application site. There is presently a lock gate at the end of the footpath. The proposal includes the demolition of the existing buildings and a mixed-use redevelopment of the site. The building would include a podium level above the ground floor that would be used as a communal terrace. The proposed building will be set back from the site edges to create a significantly enhanced public realm and active frontages, particularly along Mendip Road. In the northern part of the site, there would be an area of public open space that would meet the existing footpath leading to the river. There have been significant objections from the occupants of Battersea Reach to the potential opening up of this footpath, with particular concern regarding crime and antisocial behaviour. The proposals have been reviewed by the Metropolitan Police Service, who are satisfied with the proposal if this was to become possible, subject to further details to be secured by Section 106 obligation and condition. Discussion on the boundary rule and gate between the application site and Battersea Reach is covered in paragraphs 2.17 to 2.35 of the committee report. The proposal would provide 131 build-to-rent residential units and 193 shared living units. These would be sited at first floor and floors above. The shared living units would have access to a range of communal amenity facilities, including shared kitchen spaces and a lounge area. It is noted that 46.6% of the build-to-rent units are 1 bedroom, whereas a local plan policy requires this to usually be limited to 20%. There are currently 239 shared living units under construction on the site opposite, which combined with the proposed would total 432 single occupancy shared living units in the immediate locality. By comparison, there will be 407 bed spaces within the build-to-rent component of the proposal. The applicant has undertaken analysis in relation to the proposed potential concentration of shared living units, which can be found within paragraphs 1.31 to 1.42 of the committee report. At basement and ground floor levels, there will be storage space, office space, including co-working and a cafe. It's also important to note that the site is in an employment protection area. In such areas, local plan policy requires that there is no net loss in employment floor space. The proposal would result in a loss of 3,150 square metres of employment floor space. In relation to the financial viability of the scheme, the Council's financial viability consultant concludes that with no discount to the workspace or housing, the scheme will be £17.5 million in deficit. However, the applicants have offered 14 units, representing 11% of the total build-to-rent units, and these will be at London living rent. However, when this is applied across both the build-to-rent and shared living units, the total amount of affordable housing is 7% by habitable room. In addition, the applicants had offered 20% of the office floor space and 10% of the storage area at a 20% discount to market rent for a period of 25 years. The council concluded that this offer would increase the deficit to 21.2 million. However, the GLA considered that with this offer, there will be a surplus of 5.1 million. It should be noted that since the committee agenda was published, the applicant has increased their discounted workspace offer from the 20% of the office floor space to all of the office floor space discounted by 20% for 25 years. The applicant's justification for such a large deficit is covered from paragraphs 10.4 to 10.9 of the committee report. An explanation of where and why the council's viability consultant and the GLA differ on the viability outcome is detailed in paragraphs 10.10 to 10.16 of the committee report. Right, this slide shows the Mendip Road elevations and York Road elevations. The building itself would include a 2-storey basement. At first floor level and above, it would have an L-shaped form that is broken into 4 components, thus up between 8 and 13 stories high. The building would be primarily finished in brick in 2 different shades of grey. The taller section would be finished in white glass reinforced concrete. The first image on this slide shows the building height and massing when viewed from the north side of the river. Noting it is lower than the Battersea Reach development on the right and taller than the other development to the left. The second image shows the public realm works along Mendip Road, including a wider pavement, premium materials and planting. The third image shows the massing and communal terrace when viewed from the upper floors of Battersea Reach. In conclusion, as detailed within section 22 of the committee report, whilst there are a number of areas that comply with local plan policy, with the proposed public realm improvements and notable benefit, there are some areas that do not. As mentioned earlier, there would be an overall loss of employment floor space, which would be contrary to local plan policy. However, the applicants have sought to mitigate this with their discounted workspace offer, which since the committee agenda was published, they have improved. In addition, other areas of non-compliance are summarised in paragraph 22.20 of the report. However, when all material considerations are taken together, officers consider that, on balance, there will be enough benefits to outweigh the harm identified. The application is therefore recommended for approval, subject to conditions, the completion of the Section 106 agreement, and Stage 2 referral to the GLA.
Thanks, Mr. Wilson. That's a very helpful and balanced phrases. Thank you for that. Very complicated application here, I think, with some very positive aspects and some not so positive ones. So, colleagues, I'd appreciate your thoughts on those ones. Councillor Crivelli, I think you've got your hand up first. Over to you.
It's just to follow on with the last point that the officer made. I see that in the conclusion on paragraph 4.91, it says it's concluded that there are some harm to residential amenity of adjoining occupiers arising from the development. And it says the harm resulting is very minor, whereas in other cases there's loss of light which would be noticeable to occupiers. The losses identified must be weighed in the planning balance. it's certainly that paragraph sounds as though this application carries a very negative impact, well, at least a substantial negative impact. But we're being asked to, in effect, take the view that, yeah, there is a negative impact to the residential area around it, but the accommodation gain is worth it. I'm not aware that we've had an application before us where the officers accept that there is such a negative impact. I'm talking about, as a precedent, have we ever had an application before like that, where we've had the officers accept that there is a considerable negative impact from this development? Because I think this perhaps maybe in respect points to a lot of the negative aspects of this application.
Mr. Granger, do you want to take that one?
Thank you, Chair. I'm Nigel Granger. I'm the East Area Team Manager. Knowing this particular area and this designated focal point over the years, and certainly since it was before it was designated as a focal point, there have been a series of applications where existing buildings that have had low impacts due to their previous industrial or retail natures, namely this relatively not tall building in terms of the existing built envelope of the access self-storage building, the very open site opposite where the co-living scheme is currently being built out, and the very large shed that occupied the near hectare site at the home base site just further up where the Royal Academy of Dance is relocating to. The impacts that were felt by existing neighbouring occupiers have been equal or certainly comparable to the impacts that this proposal would exert by virtue of the existing low-level nature of the buildings on the site. So I don't think this isn't within this locale putting forward a proposal that is completely at odds and has not been considered previously by this planning committee. So there have been similar instances where existing occupiers have felt impacts by the increase in built envelope as in similar other proposals.
Thank you. Councillor Carpenter?
Thank you, Chair. I share the concerns of the Ward Councillor and Councillor Crivelli. I mean, in paragraph 2220 on pages 265 to 6, as the officer has said, there's a huge catalogue of planning non-compliance with policies. And I'm just very surprised officers are recommending this, given the large number of areas where there quite clearly are grounds for refusal. I wanted particularly to concentrate on the loss of industrial space. We're losing 27% of that, and we know we're short of industrial space in the plan going forward. So I think that's a very powerful reason for not going forward. We've also got this mix of build to rent and co-living. Now our plan, which is currently out for consultation, basically says that we only approve co-living if it's not suitable for normal accommodation, and yet the same site's got both on it. So we're consulting on something which is against what we ourselves are putting forward as a plan. On the financial viability, I have considerable concerns. I mean, I actually think that the developers are actually looking at a very different existing use value to the one that we've used. And if you read the small print in the our viability assessment, the consultants say they're not competent to opine on the existing use values. They've just used the ones that have been provided by the developer. So really that somewhat undermines the quality of that assessment. So I won't go through the full catalogue, but I really think that this is basically a misconceived application, and I think we should turn it down.
Thanks, Councillor Carpenter. Just before we move on, I think it might be helpful because, as you say, it is somewhat disconcerting. There's that big discrepancy in those numbers from 21 million on one side negative to a 5 million plus from GLA. I wonder if we could get some just advice on how that's reached and why there is such a discrepancy in those two lots of numbers.
Through you, Chair, may I suggest that Mr. Ruig does sort of introduces the overall position with the viability, and we also have a gentleman called Mr. Nicholas Pell from BNP Paribas, who was responsible for providing us with independent viability advice for us in terms of assessing the applicant's offer and negotiating and assessing what the aspirations of the GLA were and are.
Thanks, Mr. Granger. So, Mr. Ruig, good evening. Welcome to you. Would you like to carry on?
Good evening, Chair. My name's Ian Rueg. I'm the Head of Housing Enabling and Projects at Wandsworth Council. As is set out in the report, the Council has gone through a sort of robust assessment of the applicant's viability statements, and including the benchmark value and the existing use value that Councillor Carpenter refers to. I'll leave Mr. Pell, who's joining us this evening, to go through the finer detail of the financial viability report, but the conclusion that's been reached is that the scheme is in effect circa £21 million in deficit with the proposals in front of you this evening. The applicant has, even though that deficit is stated and agreed, is offering the council 11% affordable housing, and we've particularly focused that affordable housing offer on the build to rent units, and I would draw members of the committee's attention to the fact that build to rent is actually built to space standards equivalent to general needs affordable rent housing, and does provide a valuable contribution to meeting housing need in the borough, which is why we particularly sought the affordable housing offer within that element of the development. But perhaps it's best if I pass over to Mr. Pell to go into the finer detail of the financial viability.
Thanks, Mr. Ruig. Good evening, Mr. Pell. Over to you.
Hi, good evening. In the first instance, to provide reassurance to the councillor, with regards to the self-storage space in the scheme, both existing and in the proposed, it is correct in our original report, we stated we recommend that the council instruct a specialist in the field. Therefore, the council instructed Cushman and Wakefield to undertake an assessment of the storage space. They are specialists in the field, and it was important that that was undertaken to enable the council to adopt a robust position. Cushman and Wakefield undertook their assessment, and we've relied upon that in our wider viability assessment. So I hope that provides you with some comfort on that point. If I can comment briefly on the difference between our viability conclusion and the GLA's viability conclusion, there are a number of points where we differ. We have based our assessment upon our experience within the field, and we have a significant amount of experience on co-living and build to rent. In one of our most recent responses, we undertook a sensitivity analysis of the GLA position. In that sensitivity analysis, we adopted all of the GLA positions with the exception of the existing use value, which is the self-storage space that was undertaken by Cushman and Wakefield. So if you adopt the Cushman and Wakefield self-storage existing use valuation and all of the other GLA inputs, on the offer that was put forward prior to the most recent offer, the appraisal generates a deficit of circa £3 million, and therefore the previous offer was deemed to be reasonable. I do note, obviously, there has been an updated offer, as the planning officer outlined, that has come through more recently than that, which would seek to generate a greater deficit than the £3 million concluded in the sensitivity.
Okay, thanks, Mr. Powell. That's helpful background stuff. Colleagues, yes. Councillor McDermott.
Yeah, thank you. I share some colleagues' concerns about various things, particularly the loss of employment floor space and the many one-bedroom units. But I particularly want to pick up about the crime, because Councillor Morgan has picked that up, and obviously the Battersea Reach Residents Association have. It's not particularly mentioned in the main report, but I see it was picked up in the addendum we had just recently. It's difficult to know what proof we have, because it seems to be a bit of a problem between what the police say and what the residents say, and it doesn't seem to match. And also, it'd be useful to know what sort of weight we can put on crime as a material planning consideration. Is that, perhaps we could have some help on that, please?
Good question.
Thank you, Chair. The issues, I mean, the way that planning applications are assessed is obviously we don't, as planning officers, we ask various technical advisors to contribute to the overall assessment of a planning application. And when it comes to crime and antisocial behaviour, we ask the Metropolitan Police Services crime prevention design advisors. They've got a slightly updated name, but essentially they are there to assist in terms of crime prevention and design, making buildings less attractive to engage in antisocial behaviour and crime. So that person, the person that advises the council, has experience in this, is a professional, and we are guided. They have also access to crime data and crime hotspotting through their own criminology teams. So they have a range of information and tools available to them in order to target their own observations and apply their own training in terms of how to improve the public realm, or certainly redesign or think about buildings that are proposed and how that would interact with existing situations or existing parcels of land, particularly like this, where there's a potential to link this application site and the adjacent Ensign. There's a small parcel of Pocket Park opposite an existing wall. Now, the crime, I mean, it's difficult because there's lots of anecdotal evidence that's been contained within a report that was commissioned by the Battersea Reach estate that's highlighted lots of antisocial behaviour, but that hasn't necessarily been picked up by the Metropolitan Police and the advice that's been contained to advise us or to allow us to arrive at a conclusion or a planning balance on this particular proposal. So there is, I am aware that the Battersea Reach Residents Association has raised objections to the notion of opening or effectively demolishing an existing wall that would allow more permeability through the estate to the Thames. But there's a number of paragraphs dedicated to that issue within the committee report that highlights the legal complexities of achieving that ultimate goal. That, as a planning officer recommendation, that's certainly something that is a planning gain in terms of any public realm improvements or permeability improvements for the general public at large. Is something that is considered or regarded as a positive thing. However, we are aware that it is complex, and that is why it's something that at the moment neither party can provide equivocal evidence as to what this wall, the ownership of certain sections of the wall, and the egress of these walls, whether they're easements, things like that, is complex. So there is a best endeavours clause within the section 106 planning obligation to put an onus on the applicants at their cost to explore further the possibilities of realising this public realm improvement that us as officers in the Metropolitan Police Service support. But ultimately, for various factors, that will be, if this application is approved and that clause is obviously worked on and information submitted to the council, then there'll be a situation where all of that work will be put into one piece, and we, as officers, we can see what work has been done in order to potentially realise that public realm improvement. It doesn't say the reasonable endeavours clause doesn't categorically state that this is going to, it can happen and will happen. If it can happen and both parties are in agreement, then part of the clause is to facilitate those works at the applicant's cost. But it's certainly based on a robust explorative process in order to learn how that ultimate public realm improvement can be delivered post any resolution that may take place tonight. And it does tie in, that would be only at a point when it ties in with the, you know, the overarching crime prevention or real or perception of crime within the Battersea Reach Estate as a larger piece.
Thanks, Mr. Granger. Just to follow on from that, just to be clear, and for the purposes of determining the application tonight, as you say, it is quite a complex and not necessarily fully concluded discussion between the neighbours in this part. Could we get some reassurance from officers that because I do see that pocket park and that green space as one of the assets of this application. So just want to say, if that were not to conclude successfully, do officers feel confident that that would work in isolation as a amenity space and a green space, even if there were no possibility of connecting it through? Just for the purposes of coming to a conclusion tonight would be helpful.
Yeah, certainly. Thank you, Chair. I mean, it's important as well, based on what potentially might happen in the future, that if it wasn't to happen, what is the benefit that officers think that actual space provides? It's a large enough space to actually. The conclusion is that the space is large enough to actually act as a piece of public realm that connects very well with the widened Mendip Road Boulevard that extends for the length of the project, which is a significant public gain in terms of improving the overall pedestrian environment of Mendip Road, which is quite narrow and heavily parked, and providing a second sort of far more pleasant environment with which to actually traverse down Mendip Road and arrive at a point where there is a more sort of tranquil space to pause at. So yes, we do think that this application stacks up irrespective of whether the reasonable endeavours clause actually happens.
Great, thank you. That's really helpful. I have to say, I agree with you. I think that the public realm part of this is one of the best parts of this proposal. It does make a distinct improvement to the locale, and what they're doing on Mendip Street, I think, is a really good aspect of this application. Who was next? I saw some hands up. Yeah, Councillor Byrne and then Councillor McCausland.
Thank you very much, and I do think we've got a very comprehensive summary of the objections that were very much pitched at the language of this committee tonight to Councillor Morgan, so thank you very much for that. But just following on what Mr. Granger has said, and this may come back, refuse tonight, I'm afraid that the nature of development in this city is that this, if we refuse it, this may come back. And you may remember Councillor Richards-Jones, who's moved on to higher roles in the council, but was on this committee, and one of his favourite expressions was that the genie was out on the bottle on certain matters. So a tall building in Wandsworth that residents are objecting to, I mean Wandsworth town, he said, but the genie's out of the bottle. And I'm afraid the same here is the case, that along the river, especially here, I'm afraid that tall buildings are the norm now. And with regard to security, I think, as you say, Councillor Humphreys, sorry, so I'm looking at your name there. Getting old, aphasia. That you know, this very well lit path is actually maybe an asset rather than a security risk. And then there are the queries about accommodation, and I think we do, and what voters are telling us now, we're out campaigning every night, is that we do need a mix of accommodation. We need shared room, we need built to rent. I remember we were on the committee, we approved the first built to rent in Nine Elms. So we do definitely need this, and I find in the objection comments, and no disrespect to the objectors, but they are part of the community, but equally people want to be part of their community. And they have many, many assets there, like the Royal College of Dance, which was built on a demolished chain store. It was then squatted on by people and so forth. And we have even the front of the Sunday Times last on Sunday just gone, saying how their local pub, the Ship, is a mecca for young people. So I do think that if this comes back, it'll be very hard to refuse. The developer and the residents should know this, could go to the planning inspectorate, and the council then will lose.
Okay, thank you, Councillor Byrne. It's good to get all points of view. Councillor McCausland, you were next.
Yes, Chairman. I mean, I think it's the sort of application we could talk about all night, and the sort of difference in antisocial behaviour and low crime and statistics, lowest crime in central London, in Wandsworth, etc., etc. But I do get the sense that permeability, which we were always aiming for in the public realm, is maybe coming under a bit of pressure now. I just wonder really if it is a good idea to put this path, which goes down to the river, through a locked gate. I don't know why the gate's locked, but why they have to send it through Battersea Reach instead is slightly beyond me. And I would have some sympathy with Battersea Reach residents, actually, in keeping their lock gate and opening the lock gate to the river path, which is surely what we're sort of hoping the residents, people in the borough, whether they're visitors or residents or whatever, can get to the river. But the other thing, sorry, I'm just making general comments, but that was on the sort of antisocial behaviour type of thing. But I do have, as you may know, big concerns about the way that co-living is suddenly arriving in the borough. I mean, 3 years ago, I think it was 3 years ago, we had the first application by the collective, which has been built out. I'm sorry, it's still being built out. Sorry, it's not built out yet, which is exactly opposite this development. And it's got, I've forgotten how many, 230 or something? No, 190 is it? How many co-living there? And it's just the other side of the road to this development, which wants to put basically double the number or near about double it. It's got a small amount of build to rent, small amount of co-working, I think they said. Co-working, I mean, that's an interesting concept. I suppose that goes with the co-living area, kind of on the ground floor, so it's quite small scale. And then you've got these offices, which are supposed to be very affordable. And then you've got the storage area. It seems to me that it's all a bit of a mishmash. And personally, I think it's all rather experimental.
Okay.
You know, given the sensitivities in the area, both across the other side of Mendip Road and to the west, immediately to the west, which is Battersea Reach, not to mention the residential along York Road on the south side of York Road.
Okay, let's.
I think it's a bit incendiary, really, just waving this through. I think it's. I wouldn't be terribly happy. It would be, I seem to be using the word experimental a lot tonight, but this would seem too experimental to me, I'm afraid.
Yeah, thanks, Councillor. I think we're certainly not in danger of waving it through tonight, the way we're having a discussion. I just wanted to delve into this point about the quantum of one beds, as Councillor McCausland's raised. It's I mean, it's not unknown for us to go against our own policy and have a slightly larger number. But I think what makes the difference in this case is that not only have we got the high percentage in the build to rent, but we've also got the extra in effect co-living space, which is also single occupancy units. And I think it's that totality that I've got an issue with particularly. And I know they've tried to put some affordable into 11%, but it's only 7% by habitable room. And I just think that's the combo in this particular instance that I think is more worrying. That it's the high number of single bed units across the totality of the site, which makes it really tricky, I think, for me personally. I just wanted to touch on the employment space. That's something that Councillor Morgan's raised as a quite significant issue as well, which, as Mr. Wilson said, is contrary to policy. So obviously the applicant is keen to progress with this, hence their last minute offer, much more generous offer on the affordable space and the discount on the entirety of the workspace, which is a much more generous offer. But we are still having that 27% loss in employment space, which I think, as Councillor Carpenter actually referred to earlier, is a significant thing in the borough where we're trying to generate employment. It's a big strand of what keeps the whole community going, and I'm not sure that loss of the workspace and employment space is going to be something that is sustainable on this particular application. Although, as I say, it has got a lot of merit as well. But colleagues, yes, Councillor Mowat, over to you.
Sorry, it's just a quick comment. My main issue with this application is the, from what I can see from this application, as a lack of evidence to support this co-living shared accommodation. For example, in paragraph 1.44 in the strategic housing market assessment, it's not up to date and does not specifically conclude or provide an assessment of the need for large-scale purpose-built shared accommodation. And then in the conclusion, it says, in relation to the shared living accommodation, in terms of the local plan, it is largely silent on this type of development proposal. So I just feel that my main issue with this application is there's just not enough evidence to support. Whilst we appreciate, as Councillor Byrne said, there's a huge pressure for housing, I just don't think it would be fair to approve this application, given the experimental nature of it.
Thanks, Councillor Mowat. Councillor Loveland.
Thank you, Chair. I think the issue about the permeability in the open spaces, I think actually is one of the pluses of the scheme, actually, I have to say. That said, I think there are a number of issues with this scheme which, if you add them all up, I think really do weigh very heavily against it, I have to say, in my view. The lack of affordable housing that's on offer, and in fact, I did look at the stage 1 letter. I know it's moved since then, but I quote from the GLA's stage 1 letter, as he says, rapidly trying to turn his pages. It says that the absence of an affordable housing offer is wholly unacceptable. I know we've moved on a bit since then, but of course that moving on has been constructed in terms of how this scheme, as it's been put together, is considered viable or not. So in a way, the viability construction flows out of the fact that this is a certain combination of uses. I mean, a different combination of uses would generate a different viability, and we'd be in a different place, it seems to me. So there's the affordable housing content. There is a view that it is an over-concentration of this sort of use, as has been said. There are light impacts, in fact, as the report recognises. There is a loss of employment floor space. And I think when you add and the number of small units, which you yourself have said, Chair, when you put all that lot together, that seems to me to be a pretty solid set of reasons to why this might be considered unacceptable. And the one other question I wanted to ask, because this has been raised by Councillor Carpenter, and I think it was raised by the Battersea Society, I don't know what the status of the emerging local plan is. We're now at Reg 19 stage, so it's gone through Reg 18 consultation. It's underpinned by an evidence base, including strategic housing assessment, which, as Councillor Mowat has said, doesn't support this. Does that have any weight? Because if you look at, certainly if you look at policy LP29, housing with shared facilities, and you look at clause C of that, it seems to me that this would actually be quite contrary to that emerging policy. I think there are certain enough policies in the existing plans here to throw at it, but I think if you look at that as well, that's an added piece of weight that maybe we might want to put on the table. If that has any status at all at Reg 19 stage, I don't know.
It's a good question because, as you say, it's emerging policy, so it would be helpful, I think, for everybody to get a bit of an overview of how much weight we can put to that.
Yeah, thank you, Chairman. Thank you, Councillor Loveland. The situation with the local plan, obviously, it's a Reg 19 consultation at this stage, hasn't gone to the inspector. We have been given it little weight to no weight at this stage, and where policies have received objections, they will get very little weight going forward. This is one of the policies which has received objections from developers, as you might expect at this stage. So it is one that we couldn't rely on at this stage. But as you note, there are other policies in the London plan and local plan that we could rely on if members are concerned about the high level of smaller units.
Thanks, Mr. Gordon. That's helpful. I don't think I'm wrong in getting an impression from the majority of colleagues around the table that people aren't thrilled with this application for all sorts of reasons. Therefore, I think if we go to a vote, then we can craft a resolution accordingly that way round. Do you want to do that first?
Yeah, what I would suggest is that we sort of pinpoint the areas. I think the feeling from members is there's more concerns about the application. So if we can highlight, obviously, one issue that's come up consistently is the lack of and the loss of employment floor space. So we could use that as a reason, and also this high level of smaller units, both the one bedrooms and also the mix with the non-self-contained accommodation that we could combine inwards. That could be two reasons for refusal. I would probably rely less on the impacts of the loss of light, because as Mr. Granger has set out, that is a similar situation. There's a benefit at the moment from the low level of that building in an area where there's generally been higher buildings, so you'd expect some losses of light, and I think that would probably be a weaker one if we went forward with an appeal. But I think if members want to kick around those two major reasons, I think that might be a starting point.
Thanks, Mr. Cole. That's really helpful. I think, yes, my instinct is to use those tools we've got, which are the strongest ones in policy terms at the moment. So the affordable, the quantum of workspace, which is below requirements, and the oversupply of the one bed, and the quantum of that in totality, which are two quite strong policy areas for consideration. I think we should perhaps mention as a subsidiary thing the fact of the co-living, although it is only emerging policies. I think that is a salient point in the discussion. But I personally think the bulk and mass is not unreasonable in the context of that building. And as Councillor Byrne was saying, referring to what may come in the future, I think it's something we don't want to bottle it down too much. So I think that's actually bearable in the circumstances of where we're at. So, colleagues, are you relatively comfortable with going along those lines of those two major grounds, the loss of employment space and the oversupply of one beds, as both being contrary to policy? If we could craft something along those lines.
Yeah, what I suggest, if we take those away, and we can provide you and maybe yourself and Councillor Loveland as well could agree those, but you'd need somebody to put those forward and obviously second them. So.
Colleagues, I'm asking for hands up to. Oh no, colleagues. So would somebody like to propose that as a grounds for refusal and a seconder, please, on that one? Councillor McDermott, that hand went up really fast. Councillor Loveland, do you want to second it? There we go. So the proposal, therefore, is to refuse on those two grounds. The details to come back for detailed description later on. Those in favour of that refusal? That's everybody. Yeah.
Before we actually finalise that, what it will do, it can go to the GLA as well, because they can either direct refusal themselves or call it in and go for stage 3. So you're resolving to refuse planning permission. That's just the clarification I had to do.
Thanks, Mr. Gordon. Yes, we have that.
Mrs. Jackson, I think.
Mrs. Jackson.
Sorry, Chair, I didn't want to put you off your stride earlier. I simply wanted to observe that the report recommends a Section 106 agreement to secure the affordable housing. Obviously, if you were to refuse the application, there would not be a Section 106 agreement. So there would be I think, a holding refusal reason, effectively, in the absence of a legal agreement to secure the affordable housing type of refusal reason. So I was going to leap in, but I didn't quite get there fast enough. I'm not sure whether Mr. Moores agrees or not. It's a problem with sitting across the other side of the room from me.
Chairman, thanks very much, Mr. Jackson, for raising that point. The only thing I would add to that is that we wouldn't want the 106 agreement, or the reason for refusal for the lack of a 106 agreement, just to be limited to securing the affordable housing. It's for all the heads of terms within the committee report.
Thank you, colleagues. That's much clearer. Thank you. Appreciate that. So yes, colleagues. So with that noted by colleagues, the committee has agreed unanimously to refuse that application on those grounds. We'll get the detail. Thank you, colleagues.
Thank